to go ahead and explain what's happening. And these are extemporaneous remarks. I'm not trying to read from a script. And I do welcome any questions that you may have. Basically, we're in a situation where on Monday, the Baker County Circuit Court issued a preliminary injunction which established that the executive orders issued by the governor as to the public health emergency in the state no longer were enforceable as to the extraordinary powers that the governor has under the public health emergency statute, because the judge determined that the public health emergency statute, 28-day expiration date on it. One of the things I have noticed that nobody seems to be talking about is that does not mean that the executive branch is powerless to deal with the issues that confront us in regard to the coronavirus pandemic. There is an entire chapter of state law, ORS 431A, chapter 431A. It's an unusual numbering because that chapter was inserted into the law, and there is an entire public health chapter of the law that allows a variety of steps to be taken dealing with public health. But it does not allow the governor to issue more public health emergency orders and to shut down churches, restrict churches, shut down businesses, restrict businesses. All of those extraordinary powers, and it's our position, are limited. And technically, the public health emergency law says the governor can have those powers for 14 days. She can extend them for 14 days more. Then the powers expire. And as you're aware, the state is taking a position that the general emergency law going back to 1949, which we say is usually for storms and floods and fires, that has no expiration date, and that connected with the public health emergency law means that the governor's public health emergency declaration and powers did not expire. That's the issue that's up in front of the Supreme Court. Monday, they issued an emergency stay, meaning that they were temporarily suspending the application of the injunction so that the governor was not prevented from doing everything that she has been doing under executive orders. But they also asked the Pacific Justice Institute and Ray Hackey, who are representing the original plaintiffs, and they asked me, representing the interveners, to file what I'll call supplemental briefs. They're not really, they're memoranda in opposition that needed to be filed today. And we are about to file our brief this afternoon, our memorandum in opposition. After we have filed it with the court, we will put the entire brief, again, I call it that, the memorandum in opposition, on the Common Sense for Oregon website so that you can see all the points that we are making. But I thought today it would be helpful for me to answer any questions that the media may have about where we are in this process. Well, so far I see everybody muted. Maybe I need to unmute you. If I'm missing out on that, let me know.
Kevin, this is Dick Hughes. Can you summarize your response to or your brief to the Supreme Court? I recognize this may be difficult for a lawyer because it's complicated, and I mean that sincerely. But can you summarize the key points and what you see as the key flaws in the state's case?
I'll try to do that without giving you the deep, dark background. I'll mention from the beginning, our position is the common law, which came to the United States through the American Revolution. The English common law applies in our states unless our legislatures and our voters have limited it. And so the common law inherently allows the sovereign to take action in regard to extraordinary situations. And there's hundreds of years of English law on that subject. But in Oregon, our legislature has legislated on the subject to the exclusion of the common law. And so our original position is, well, the general emergency law is there for the kinds of emergencies I've talked about. There's no time limit. And why is that? Well, if you have a flood or a forest fire or a storm come through, the general emergency law talks about intervening, using local police, blocking roads, providing immediate housing for those who are dispossessed, all of those things, and then clearing up debris, rebuilding. So if you're going to rebuild a bridge or rebuild a road, going to take more than 28 days. So a declaration of emergency under that law, we can understand why it has no time limit. That law nowhere refers to a public health emergency. After the SARS pandemic, the Oregon legislature passed comprehensive legislation in 2003 and again in 2007, where they started out talking about public health emergencies generally in 2003. In 2007, they wrote a comprehensive system of laws that allow the counties and the state and a new state public health director, a new position, to work together to deal with outbreaks of disease, to deal with toxic substances, to do whatever needs to be done to provide for the public health in the community. And in that same legislative scheme in 2003 and 2007, then they said, in the case of a communicable disease pandemic or epidemic, that's actually the word they use, declare a public health emergency, and then the governor has these extra powers to intervene. That's still what this controversy is about. Now, our argument to the court is going to be, first of all, trial courts are given a certain amount of leeway. The interpretation of law is going to be pretty black and white, where we go there. But the trial court was exercising its discretion in allowing the preliminary injunction, and we're going to be arguing that needs to be respected. The trial court considered all of the factors that are applied. What are the equities? What's the irreparable harm that's being suffered? What's the public interest? And what's the interpretation of law? How likely are we to succeed? And ruled in our favor with all those considerations. Now, the Supreme Court will probably be looking at all of those same factors and deciding whether or not they're going to allow the preliminary injunction to be put back into place. The sub-arguments have to do with a variety of other things. We've pointed out that the governor, if things are really as bad as she said they were, and we think they are terrible, the governor could have declared a catastrophic disaster. And that's even a bigger emergency. But guess what? That provision has a 30-day time limit on it. So if you have a 30-day time limit for a catastrophic disaster, which includes a public health emergency, which is a catastrophic disaster, how is it that you have no time limit for a lesser public health emergency with extraordinary powers? We're just saying it's not logical. And we do think the legislation and the constitutional amendment can all be read together to create the scheme where under chapter, I think it's 431A, you have public health laws and your public health officers in the counties and the state can all work together. They can interview people, they can talk to people, they can gather information, they can deal with even quarantines, quarantine provisions, all of the things that need to be done as to what's happening. After that, as things proceed, there is the public health emergency statute and the specific provision that allows the governor to declare that. And when she declares that, she has some very powerful tools at her disposal to tell people to stay home, close schools, tell people they can't go to church, but only for 28 days. And those 28 days expired on April the 6th. Is that a shorthand version for you, Dick?
Thank you.
And again, I'm seeing a bunch of muted microphones. I hope that somehow we didn't cut people off.
Hi, Kevin. This is Tess Risky from Willamette Week.
Hi there.
Hey. So earlier today, President Trump declared houses of worship essential and ordered them to reopen. I just wanted to see if you had a comment on this declaration from the president and if this has any bearing on the case at hand.
Well, President Trump's declaration will not have any bearing hand to the extent that the courts are really not going to pay any attention to extraneous matters when they're looking at the record in front of them. In fact, we put on our Common Sense for Oregon website a request that people not call the courts, not write to the courts. That's inappropriate. They need to deal with the record in front of them and the arguments made by the attorneys. And at the same time, I think that in terms of the state of Oregon, I hope the governor's listening. I hope the other folks in the Oregon government are listening, that one of the points that our friends at Pacific Justice Institute make, and we agree with them, are that religion cannot be treated any less than you treat anything else. And one person that I know said he was at Costco and he asked them, the person who's doing the clicking at the start, how many people are in Costco right now? 1,101. Now, sure, Costco has its own protocols. They're asking you to wear safety masks, but they're allowed to be open and have 1,101 people present in their store. Yet you go down the street to your community church, and if they have 26 people in there, one person more than 25, they're committing a Class C misdemeanor under the court's orders. They could be charged with a crime, sent to jail for 30 days. I'm getting off. I got to get back. But I'm just saying the president's sensitivity to religious freedom is laudable. And I have not read the full text of his remarks. I don't think it has any immediate impact in terms of the legality on this case. But I do think it's important for all of our public officials to remember that freedom of religion has a very special place in the American Constitution, just as all of you who are members of the media are protected by freedom of the press, freedom of expression, as it's said in the Oregon Constitution. So I'm pleased to hear him speaking out on this, and I hope the governors pay attention.
Okay, thank you.
Kevin, a follow-up to that. The president also said that he will override the governors if they choose not to. Are you able to clarify if is that legal?
Well, I'm smiling only because actually we do have this federalist system, and actually, in reality, every state has its own capability as a state, as a sovereign state, to apply the law and deal with an emergency. And that's why all along, usually the federal government is issuing guidance or guidelines, and sometimes the president speaks beyond that. But when you look at the legalities, it's up to the governors. But within each state, those governors need to be paying attention to their state laws and their constitution. I may have mentioned this earlier, but for instance, we looked up the governor's powers in a whole bunch of states, and we realized Oregon is unique. In New York, Governor Cuomo every 30 days can, issue another renewed state of emergency. In California and in Washington to the north and south, those statutory schemes don't contain the kind of specific provisions we have here. So I would say to the president, I like your encouraging words, and there is one area where he can pay attention. They could say that as to distribution of federal funds, they're going to want to make sure that they are not financially supporting anyone who is hurting religion. I don't know what you would take that to, where you go with that, but directly there's no power for the president to intervene as to each state's governor.
Thank you.
It's a good cheer, but he's not on the field of play. He doesn't get to pass the ball. Don't ask me where I came up with that.
Great. Thank you. I appreciate that.
Any other questions? Well, then I thank you all for joining me today. Stay tuned we'll put out an announcement when we've done our filing with the Supreme Court, and we'll promptly put that up on our website. Have a good day. Thank you for tuning in.
Thank you.